Is now starting. All attendees are in listen-only mode.
On the 21st Century Cures Act. Some brief comments before I introduce the speakers. So this is the second episode, and the topic today on the 21st Century Cures Act is information blocking. And Helen Oscislawski will be the speaker and expert on this domain today. Previous sessions are available on our internet, HSX University. And so therefore also this session will be recorded so that you or your colleagues can view it. The recording has just started. You're welcome to ask questions during the webinar. Please use your questions box that you see on your screen, either during the presentation or after. I will read them to Helen as the time is right, but please feel free to enter your questions as we go. I would like to welcome you all and thank you for joining this webinar. I'd like to start by introducing Don Reed, the Chief Operating Officer of HealthShare Exchange.
Thank you, Harm. Good afternoon, everyone. Welcome to our second in a series of 4 HSX University webinars, focusing on compliance with CMS and ONC regulations, along with information security, which will come later in our series. Today's topic is going to focus on HSX support and compliance with the new information blocking rules. And before I introduce our guest speaker, I wanted to first take a moment to thank Dr. Cherbier for moderating today. Thank you, Harm. Secondly, as you know, HSX is an independent, nonprofit, member-run organization. The support we get from our community is essential, and we could not continue our operations without it. So I wanted to thank our very active board, our committees, our many work groups, our partners, our colleagues, all who volunteer time and help us run and operate HSX. We greatly appreciate your support and guidance through these times, which are very difficult these days. That leads me to introduce someone who has been associated with HSX for quite some time. I'm pleased to introduce our guest speaker today, Helen Oscislawski. Helen is a corporate and regulatory attorney who's practiced for over 20 years, has focused almost exclusively on advising and representing clients in the healthcare industry, including HSX. Selected to the 2020 Super Lawyers list for healthcare law issued by Thomson Reuters, as well as her firm is also included on the Best Law Firms in Healthcare Law list issued by Best Lawyers from 2018 through 2020. And her firm is a boutique law practice based out of Princeton, New Jersey, but with a national reach. She cemented her reputation as a prominent privacy and health information attorney through decades of developed experience in working hand in hand with C-suite executives and in-house general counsels on how to structure and manage complex data sharing arrangements in compliance with applicable federal and state privacy laws. Helen has been integrally involved with and has been advising HSX for many years on privacy issues since its inception. She was instrumental in helping us negotiate a complex data sharing agreement between HSX and dozens of healthcare organizations, many attorneys in the Philadelphia region, which set the baseline for balancing privacy laws with the goal, of course, of improving the quality of healthcare through sharing of patient data between organizations. Over the years, Helen has regularly participated and often led discussions in our established privacy and security work group, which is charged with vetting and reaching a consensus on a variety of new and one-off use cases pursuant to which the participants of the HSX network exchanges data. So as HSX moves into this new era of federal policy and regulation, prohibiting information blocking of electronic health information by providers, health information exchanges, and health IT vendors, Helen continues to lend her deep experience to assist HSX in its data sharing participants, carefully maneuvering their way through new challenges where privacy, consent, and security are now exceptions to the rule. With that, I'm pleased to turn over to Helen, and we're very gracious and thankful that Helen is able to support us through these times. Helen, I turn it over to you.
Don, thank you so much, and Harm as well, and to HSX for putting on these fantastic educational webinars. I'm sure they've been very well received, and I'm honored and thankful to be a part of them. And I anticipate hopefully sharing some of the education about the information blocking rule. I have done a very deep dive, discovered some things that even surprised me in the preamble. And so I'm looking forward to potentially a robust discussion. Encourage your questions, invite them. We will try to get to them. I'll try to answer them. And I also like to offer, to the extent that we can't get to your questions, please feel free to enter them into the chat box. Harm, I think, is going to interject if he sees something that segues or ties into something I'm speaking on. We'll try to pepper those throughout the presentation. If not, then we'll either try to capture them at the end, or if for some reason we run out of time, I'll do my best to follow up with maybe a Q&A to the participants if we can put that up in some form or fashion or disseminate that. So with that, let me get my my screen up and we can get started on information blocking. Okay, so the topic today that I would like to cover, and we're not going to be doing a deep dive into this by any means. I just completed a 3-hour workshop over 2 days that took a granular and very specific look at the nuances and the specific interpretation by ONC of a variety of these elements and how their interpretation of the standards in the information blocking rule. It's very dense, and in many such situations, it's actually quite complex and confusing. So we're not going to be able to unpack all of that. We have 1 hour today, including with questions, but I'm going to do my best to hit the high level and also focus in on a number of examples that I think have practical implications for HSX and those participants out there who are members of or are interested in exchange with a network in Philadelphia. So with that, high level first, right? So who applies or who needs to comply with this new regulation referred to as information blocking? And there are only 3 categories of what are called actors that are potentially going to be subject either to civil monetary penalties or other appropriate disincentives, as ONC says. And those are healthcare providers, health information networks and health information exchanges, and health IT developers of certified health IT. Each of these terms is specifically defined and carefully defined and went in through some revisions since the proposed rule. Starting with the healthcare provider, we see that they've pulled and dovetailed or taken the definition of healthcare provider. So for purposes of information blocking, if you are any of the types of healthcare providers that are defined in the Public Health Service Act under 42 USC 30JJ, you would be the type of healthcare provider that would be required to comply with information blocking rule, or to put it another way, you would be prohibited from engaging in prohibited information blocking practices unless you can fit your practice into an appropriate exception. You can see here, of course, some of the larger examples of the types of providers that we know that are part of health information. HSX would be hospitals, skilled nursing facilities, nursing homes, FQHCs, large group practices, and so on and so forth. So they are a finite list. Some things you don't see on this list, for example, would be particular possible social service agencies, or things that maybe or agencies or entities that could be providing in quasi healthcare kinds of services, but are not defined as such under the Public Health Services Act. So just know that that is where the actor who's a healthcare provider is a defined term and limited to those lists that are in this statute. Now we get to health information networks and exchanges, and this again is a specifically defined term in the rule. So that would be an individual or entity that determines, controls, or has a discretion to administer any requirement, policy, or agreement that permits, enables, or requires the use of any technology or services for access, exchange, or use of EHI. Most importantly, that sort of exchange has to occur between 2 unaffiliated individuals or entities that are enabled to exchange EHI with each other and it is limited to treatment, payment, and healthcare operations or exchanges for those three purposes only. So a couple of things here I want to point out. With regard to determine, controls, and administers, one of the things that changed between the proposed rule and the final rule, which I think is important for our participants and the listeners today to understand, is that originally ONC had proposed that HIE would also include any entity or individual that quote unquote substantially influences the exchange, access exchange, and use of EHI. They removed that for the specific purpose in the preamble as explained, because they felt that that created a lot of ambiguity, because there are a number of entities and individuals and entities that could have influences on how information is exchanged, but do not specifically determine, control, and administer. I think that that sort of limitation or refinement of the definition makes it clear that, for example, HSX would be the health information network and exchange in this instance, but however, the providers or the participants, the healthcare providers and participants that participate in HSX would not themselves be an HIN or an HIE, at least for the sharing through HSX purposes. That said, you would have to examine your own sort of data exchange and whether you control things within your own organization. If you're a complex healthcare system and you're exchanging information between two or more unaffiliated entities, you could be an HIE or an HIN in your own right, but as relative to HSX, you would not become one for purposes of the exchange of data through HSX. The other thing I wanted to point out is that that the focus on treatment payment healthcare operations. They focused on these three things only because they didn't want to implicate social networks, internet service providers, IT systems that solely facilitate exchange between a family and their family members. So there were a number of other kinds of data exchange vendors that could have gotten swooped into this had they not limited it to those three types of entities, or those three types of purposes for which information is exchanged. The third actor is the health IT developer of certified IT. Would be the individual or entity other than a healthcare provider that self-develops IT for their own use, that develops or offers health information technology and has one or more health IT modules certified under a program of the voluntary certification by ONC. So a couple of important things. First of all, the actor who's subject to information blocking is limited to certified, ONC certified health IT. They did not swoop in any non-certified IT vendor. They recognized, ONC recognized that there could be information blocking that such sort of non-certified health IT vendors may be engaging in, but it was simply outside the scope and the authorization that they were able to pick that up in this rulemaking. Also, with regard to individual entity, I wanted to point out that it could be anyone who offers certified health IT. That means it's not just a vendor per se of the traditional sort, such as an EMR, while those are of course included, but it certainly could be a healthcare provider, just to be mindful of that. While the exclusion that a healthcare provider that self-develops health IT for its own use is carved out, they did note that there could be providers that could be in the business of licensing out certain homegrown certified health IT. The determinative test here really would be if you hold it out for commercial use. ONC was quite clear that they did not intend this to swoop in providers for things like doling out access credentials or sharing provider portals with medical staff or with community-based providers that need portal access. So holding those sort of credentials out and providing that would not be the sort of thing that they were intending to swoop in here, and they were quite clear on that. So let's move on. So what is information blocking? What is this prohibited practice? It is essentially any practice or a practice that is likely to interfere with access, exchange, and use of electronic health information, unless that practice is required by law or one of the exceptions that we'll go through applies. On a broad brush stroke, after reading again everything in the preamble, going through the comments and responses, the shortest way to really capture what information blocking is it essentially could be anything. ONC is very clear that they intended this to be as broad as possible. So if there was even questions that went to, I apologize that my my mouse just took off without me. I apologize. So they intended to swoop everything in and not to leave much out. They intended to be as broad as possible. So anything that potentially can interfere with I'm having a little bit of trouble here. Anything that can potentially interfere with the exchange of information, health information, could be deemed information blocking. It is much like the AKS rule. You got to start with the assumption that it is information blocking and sort of work your way backwards from there. Okay. Left off on information blocking. Okay, so it's intended to be very broad, and they gave a number of examples that in both the proposed rule and in the final rule of what could be, what they, ONC, would potentially consider as information blocking. So example number one, and this is straight from, again the proposed rule. Example, a healthcare system implements a locally hosted EHR technology that's certified, and the technology developed provides the healthcare system with capability to automatically publish its production endpoints. That is the internet server that an app must call and interact with or in order to request and exchange patient data. The healthcare system chooses not to enable this capability, however, and provides the production endpoint only to apps it specifically approves. This prevents other applications and patients that use them from accessing data that should be made readily available via standardized APIs. Okay, so they said that this is an example that absolutely could be considered information blocking. Part of that is that they had a very strong theme going through a lot of the examples that when you treat one set of recipient or requesters differently than another set of requesters, if you're what they call discriminating or applying different set of standards, that could definitely implicate information blocking, the information blocking rule, or found to be prohibited information blocking. Example number two that ONC gives. Yes.
Just checking with you. Can you see the screen now? Can you see this? Your
slide? I can see your screen. Yes, thank you very much.
Good.
Excellent. Example number two, and you're spot on. Thank you, Harm. Okay, example number two. A hospital directs its EHR developer to configure its technology so that users cannot easily send electronic patient referrals and associated EHI to unaffiliated providers, even when the user knows the direct address and/or identity, i.e. the national provider identifier of the unaffiliated provider. That again, if you're discriminating between who can get it and who cannot get it, could implicate prohibited information blocking. If there are other reasons why you're making that sort of distinction, you would then need to move to the exceptions of whether one of the exceptions apply as to why you're making such a distinction, and perhaps you can fit with an exception. But right now, we're going through ONC's very broad application of the types of situations that could be information blocking. So example number three, although an EHR developer's patient portal offers the capability for patients to directly transmit or request for direct transmission of their EHR to a third party, the developer customers who are healthcare providers choose not to enable this capability. I actually got this question quite frequently and quite a bit over the last 2 weeks. And again, as you can see, ONC's very broad interpretation that itself of choosing not to enable a patient portal and the capability could implicate information blocking. Now, there are a number of exceptions that could potentially apply here of why you wouldn't enable that patient portal. For example, the privacy exception. There could be conditions precedent that we'll go through, or segmentation, or a host of other potential reasons why you might not enable and might be able to justify not enabled in patient portal. But absent those kinds of exceptions applying, again, it would implicate potential prohibited information blocking to not do so. And finally, example number four. A healthcare provider has the capability to provide same-day access to EHI in a form and format requested by a patient or a patient's healthcare provider, but takes several days to respond. This was the topic of a very robust and probably the highest, the topic that has the most comments and the most dialogue, I guess, in the preamble. There was a lot of concern from medical providers and healthcare providers as to their current practices of typically delaying that sort of information to go to the patient in anticipation that the provider typically reviews that information first or waits to review the information with the patient directly. And there's a lot of particular discussion around lab results. And in one sentence, ONC's position is that essentially, if there's no reason, there really isn't any reason to delay either the lab result or the EHI. They do not view the general sort of premise that releasing that information to a patient could cause them harm. They've set a very high standard, almost unattainable standard, and it would have to be determined on a case-by-case basis by the patient's actual treating physician to justify actually holding a lab result back. There could be other instances where certain state laws could require a holdback, which would be permissible, but the general baseline is that they view that any interference or any holding back or delaying to respond to a request for EHI, particularly with the patient, would be considered implicate information blocking. So in the next slide, the final rule does clarify a few interesting things with regard to what constitutes interference with. First of all, it's important that actors are not required, and they acknowledge that they are not required to violate their business associate agreements or their service level agreements. However, with that said, ONC noted that agreements could constitute an interference. The terms of the agreement could constitute an interference if they are used and applied or negotiated in a discriminatory manner to limit or prohibit the access, exchange, and use of EHI in a manner that otherwise may be permitted by HIPAA. And I'm going to read here, and I quote, that those sorts of BAA agreements would need to be, looked at. And certainly, if a healthcare provider is applying those sorts of restrictions in a discriminatory or non-consistent manner with other, depending on who the requester is, there is, those sort of provisions and terms in the BAA agreements would need to be looked at carefully to ensure that they are not restricting access, use, and disclosure or exchange of EHI in a discriminatory fashion. The other thing that that ONC noted that would not constitute interference with is educating patients or plan members about privacy and security risks posed by apps they chose to receive their EHI, and this would not consider interference with. You can see the fact that even somebody or commentators submitted those kinds of comments and questions show the concern of the breadth of how ONC might interpret those provisions. They were concerned that even providing some sort of educational brochures or having a conversation with the patient about certain apps could constitute, or ONC would look at that as possible interference with the sharing or giving of the EHI, the electronic health information, to the patient. And ONC said, okay, no. You can provide or you can educate patients on the privacy and security risks of a particular app. However, you cannot prohibit or prevent the patient from using that app, even if you know or have determined that the app actually falls below certain best practices for privacy and security practices by third parties, who might not all be BAAs, of course. They went so far as to suggest that there could be a way of implementing that the industry will create best practices. They laid out a bullet list of possible best practices for privacy and security measures, things like, for example, the app developer putting out transparency in terms of how the patient's data will be used, who they share with, so on and so forth, a consent to use. And they suggested that sort of litmus of privacy and security could somehow be queried or somehow baked into interfaces and the APIs that would allow, for example, a healthcare provider or a HIE to determine exactly what the level of privacy and security practices a particular app has. You cannot prevent the patient from sending or requesting to send the information to the app if they really want it, even after the education, but this would be a step that one could take in order to at least educate the patient about a particular app and their level of privacy and security measures, which again, ONC in its discussion said is going to be okay and not constitute information blocking, okay? So let's move on real quickly to the 8 exceptions. There are 8 of them. So again, if you are engaged in a practice that you are concerned that could constitute information blocking, just like the anti-kickback statute, the best thing to do is to try to fit that practice into one of these 8 exceptions. The first 5, if you fit into any of them, allow you to completely not fulfill the request for EHI. And those 8 exceptions would require a finding of preventing harm, either privacy, security issues, infeasibility, or health IT performance. Each of these 5 have their own elements that need to be satisfied in order for you to qualify within that first exception. And if you can't satisfy the elements of the exception, then you cannot avail yourself of that exception. And you're basically hanging out in the open unless you can find some other source of or exception that would apply. The last 3 deal with procedures, and meaning that you're going to fulfill the actual request for EHI, but you need to do, or you're going to do something, you're going to restrict things in a certain way, or you're going to change things in a certain way, or you're going to, you're going to do certain procedures with regard to how you charge fees, and you have to satisfy those fees in those last 6 exceptions, the last 3 exceptions before you can proceed forward. Okay, so with the first one, if we move to the next slide, preventing harm, we can just advance to the next slide that says elements of the exception, 2 forward. Is that me or you, Harm?
That's me.
Okay, now you're having problems.
I don't like this slide, by the way. This makes it personal. This makes it personal. Good. There you go.
Okay. All right. The elements of the first exception, preventing harm. There are 6 elements that would need to be satisfied. A reasonable belief that there is that the practice that would potentially block EHI is going to cause certain kind of harm to a person, either the patient or a person. There is a scope restriction. There is a very specific type of risk that needs to be assessed and found, and there needs to be a type of harm that needs to be assessed and found. There is a patient right to review in certain cases when it's applicable, and there has to be either an organizational policy or an episodic determination of that finding. Okay, if you go to the next slide, you can see, and I'm not going to go, like as I said, I'm not going to go into the details of those. I will suffice it to say that it is one of the most complex analyses because the scope of the type of risk and type of harm get into, so there are 2 types of risks that can arise. One that, I'm sorry, if you can go back, Harm, to the previous slide, I guess it will be easier to follow. With regard to the type of risk, there has to be a finding either by a physician who actually finds a particular risk and a particular test for finding the risk, and there has to then be found a certain threshold of harm, either substantial harm or that's harm to the actual physical safe and life, the life and safety of the individual. And the risk that actually can arise either it needs to be found by a physician or it can arise out of data. So for instance, if there's corrupt data or there's been determined mismatching of data, things that can actually lead to potential harm to the patient, which would justify possibly shutting down or turning off for example, a data feed or shutting off certain data or not sharing certain data until that risk has been resolved in the data. So those are the 2 types of risk, and the harm threshold is very high. So when the harm arises, for example, out of data that's been corrupted or mismatched or whatnot, it has to actually rise to the level of being so substantial that it would actually probably result in danger or harm to the patient or a person, to the life and well-being of that person, and it has to be to the level of potential physical harm. So it's a very high threshold and standard to meet. And so one of the things that ONC discussed is, for example, they don't know of any situation, because there's a lot of talk about lab feeds, and the commentators, including healthcare providers specifically, are saying, look, we believe that there's harm that could result if we don't delay the lab result from getting the patient. The patient can be harmed by this because they need to be provided that lab result in context, or that genetic test result in context. Otherwise, the patient can become distraught, confused, can take actions or whatever. So they really were proponent and encouraging ONC to recognize that holding back those types of test results until they're given some context would be a beneficial thing that ONC should consider to do. ONC said no. they said the harm threshold would be that we don't know of any example that was submitted in comment, or do we not know any example off the cuff from our experience where holding back a lab result would actually result in physical harm to the life and safety of a person. So whether you agree with that or not, that was their conclusion, and the outcome is that therefore lab results can't be held back based on that standard. Now, again, I mentioned there could be other exceptions possibly that could apply, but based on that standard, and I illustrate to that point that it's very difficult to meet. The harm threshold, what makes this also very confusing is while ONC tried to sort of, they tried, I'm sorry, Harm, you can go to the next, next slide. You can see that my whole discussion about lab results is right there. So, you know, the thing that makes this so confusing is that there's a real big overlap with the HIPAA patient right of access. And if you go to the next slide, there were a couple of takeaways from the preamble that I just want to touch on. The theme again is ONC really views that almost no kind of incomplete data, data received from third parties, mapping, duty to correct, any sort of things that are typically engaged on, particularly by HIEs and often by healthcare systems, typically they don't view that as a reason to stop data feeds or to hold back data to definitively resolve or confirm there aren't, for example, data quality issues. It would, from a risk management perspective, and historically many HIEs and health information providers or health providers and systems would hold back and often do some sort of data quality issue check when feeds were coming in from third-party sources or whatnot. And the long and short of it is ONC doesn't see many of those situations as justifiable under the harm standards that they've set. So that's just sort of the, I think, general takeaway and themes there to be aware of, that we often, what one would interpret as a justifiable reason why you would want to hold back data or suspend certain functions because you believe it could lead to harm, has to really be something that you know. So by contrast, one example they gave is if you absolutely have reason to know that a data feed coming in from a third party is corrupted, or you have reason to not just to suspect, but reason that you believe that based on certain facts and circumstances, you know, because you've seen a whole bunch of mismatched data, and there's a reason why you believe that the data coming in from a third source is corrupt. Well, if you have reason to believe that, then you can suspend data. But speculation and just presuming that any sort of data source coming in from a third party needs to be vetted and needs to be confirmed for data quality issues is not a basis upon which you can suspend that data or suspend sharing of EHI. Another really interesting example they gave is the request. One commentator talked about the fact, well, what if we know that a third party like an app has issues with data matching, or I'm sorry, patient matching, that we don't know that if we release the data to the app via a request from the patient and an API connection, whether if we know that that app has patient matching or identity matching issues, and that, or we haven't vetted them for that, and it ends up they are lackadaisical or not up to standards with regard to their patient matching or their identity matching standards, and the data then goes to the wrong Jane Doe or the wrong person, which now does that constitute a breach, or are there liabilities that arise from that? And there were actual commentary along those lines. In fact, some commentators requested that ONC consider an immunity provision that would allow HIEs and providers to avail themselves of immunity if a patient requests the data to go third-party VAP and then the app or a third, whatever the recipient is, mismatches the data or misuses it. And ONC said no. There is no duty for you to confirm that the recipient is engaging in standard practices. You have the ability, as we mentioned, that you can educate patients about privacy and security standards and best practices. If the app has or does not have them, it doesn't matter. It's not for you to confirm that they have those standards in place. So the data has to go, and what happens thereafter, they simply said, is beyond the scope of this rulemaking. So they really punted on the questions of, for instance, that I think are unanswered to some extent, is whether that would, for instance, constitute a data breach. Would it, it shouldn't, because it's a disclosure pursuant to a patient request, but there is some, lack of clarity around that, and that's all sort of going to shake out, I think, over the weeks and months to come as these provisions get interpreted more. Okay, so let's move on. I want to leave some time for Q&As. Let's go to privacy real quick. There are 4 conditions that need to be met with privacy. You can go to the next slide. Or not 4 conditions, my apologies. There are 4 categories of privacy that you can potentially meet and fit under the privacy exception. They call them sub-exceptions, if you will. So there's a precondition not satisfied. So, for example, a state law requires you to get consent, and the consent has not been obtained, therefore you do not have to share it. However, with regard to that consent element, if that is the precondition, they added an additional obligation to make reasonable efforts to actually get the consent or to facilitate if you do receive a defective consent. ONC said you have to make efforts to actually facilitate and assist getting the proper consent in place in order to allow that EHI exchange to go forward. There's a provision, there's a sub-exception for health IT developers, which is not going to apply to most of you. There's a sub-exception for denial of an individual right to access consistent with the privacy rule. So this is where it gets really confusing. And then, of course, the last one is respect an individual to request to not share info. So the patient said, I don't want you to share info. You can use or rely on that exception to not share the info. With regard to number 3, denial of access of right, if you can go to the next slide, Harm, this is the place where it gets really confusing because although they intended to not muddy the waters between HIPAA, they tried to align the standards, and in most cases they have. This is one area that becomes really confusing. And without getting into the weeds, and we can probably spend a half an hour talking on the issue between the preventing harm exception that I just spoke about and denial of access under the privacy exception under this sub-exception of denial pursuant to HIPAA standards. In one sentence, the issue is that the language as drafted in the preventing harm exception requires the determination of the patient's physician that the existence of the harm element and the standard of harm exists. While they track the same provisions for the preventing harm exception, they track the same harm standards with HIPAA. Under HIPAA, the standard is slightly different because it doesn't say the patient's physician, it says a physician, and arguably it has a looser standard, which many providers and others have applied to date. So at the end of the day, in short, I'm not really sure why anybody would go in under the preventing harm exception that holds a higher standard rather than, at least with regard to when the patient is requesting his or her own information, or their legal representative. This is also implicated in minors' rights, access of information, that you would just stick to HIPAA and go under the privacy exception and the sub-exception for HIPAA rights of access. Okay, so let's move on to security. Oh, so you can go to the next slide. I didn't know that was gonna pop up. I thought the animations were off. So next slide, there's a security exception, and there is a practice where you have to, the practice is directly related to safeguarding the confidentiality, integrity, availability of EHI, if it is tailored to specific security risks and implemented in a consistent and non-discriminatory manner, you may be able to qualify for this exception. So next slide. You have to make a determination either on a case-by-case basis that what you're doing is absolutely necessary to mitigate the risks and there are no reasonable and appropriate alternatives, or, next slide, you have to have an organizational policy that is in writing that has essentially identified all the risks and all the things that you're going to do in response to those risks, and it has to be based on consensus-based or best practice guidance, and they refer to things like NIST, and they rely on special publication 866, I think it is, or whatever, that deals with security risk management in this sort of a networked environment. So the takeaway here is that if you're going to rely on a security risk, you really have to tie the actual risk to an actual resolution. The actual thing has to be identified, and it has to follow consensus and best practice guidance. The next exception, infeasibility. If you go, there are 3 of those. If you go to the next slide, you can see that infeasibility means you cannot deliver the EHI because of an uncontrollable event like a war, a terrorist attack, a public health emergency, so on and so forth. The next one is a segmentation. So, for example, this is when most often we have the case where 42 CFR Part 2 data is linked together with data that you cannot bifurcate from one another, and the condition precedent hasn't been met for the 42 CFR Part 2 data, but they're requesting the other general health data. But since you cannot segment one from the other, it would fall within potentially the infeasibility exception for lack of ability to segment. And last but not least is an infeasibility under the circumstances. You have to demonstrate that certain factors, you have to show that there's a 5-factor test that you have to show why is it being asked, what data is being asked, who's being asked, and so on and so forth. And you can, if you can satisfy or show those factors have been met, you can qualify under that exception. So next slide. You have to let the requester know within 10 business days why you are not giving them access to the EHI and why the request and the delivery of the EHI is not feasible. Okay, so let's just whip through the last few. Health IT performance, next slide. There are, again, 4 conditions: maintenance, improvement, assured level performance, practices that prevent harm, security-related practices, and harm. I would just flip through the next content mentor. Let's stay here for 1 second. It is important to know, and some still are getting this a little confused, between still the deadline right now to begin complying with information blocking by everybody, healthcare providers, HIEs, HINs, health IT. With information blocking provision, the prohibited information blocking goes into effect, still compliance November 2nd, 2020 this year, with regard to UCSDI data only. So that is a subset of all EHI. So you are required to comply with UCSDI data from November 2nd through May 2nd, 2022. After May 2nd, and that's a typo there, I apologize, that would be 2022, full EHI data has to be complied with, okay? So let's go next. Manner, there's an actual link here. So if we do share these slides, which I'm happy to do, you can see a hyperlink there of what constitutes the current version of USCDI data. So next slide is the manner exception. This talks about the fact where you cannot technically fulfill a request. If you are unable, which is a very high standard, you may be able to fulfill the request in alternative manner. Again, if you go to the next slide, you can see that there are a number of requirements that must be met. And in fact, if you are going to do it in an alternative manner, you have to, furthermore, and additionally, you would have to comply with the fees exceptions. You cannot charge certain fees that violate that exception. And if you're going to license anything, you have to meet the licensing exception that has its requirements. So if you move to the next slide, you'll see that there's a fees exception, or the last 2 exceptions. Next slide, Harm. There are qualifications of what fees you can charge and not charge in certain circumstances. The fees that you charge have to meet those criteria of the first page. And if you go to the next page, you cannot be charging fees based on these elements, things like based on competitive nature, or whether it facilitates competition, sales, profit, revenue, costs, so on and so forth. So they're very detailed regulation of how you can charge fees when you do, if in connection with the sharing of data. The next slide points out that those fee charges and restrictions actually don't apply to patients' access to his or her own data. So the carve out for the privacy rule exception, there's a carve out also for certain electronic access. There's also a certain carve out for exportation of EHI and conversion of data. So those things don't get tripped up on the exclusion of fees. And last but not least, the licensing exception. Again, if you're negotiating a license, the next slide. If you're negotiating a license, again, you have to meet certain conditions. There are licensing conditions, conditions relating to interoperability. And last but not least, you have to, if you begin licensing negotiations, they have to be completed within 10 business days of the receipt. And you have to negotiate the license within 30 days of the receipt of the request. In the next slide, you can see that. So I apologize, I rushed through that, but that's a high level sort of overview, I think, and examples. Hopefully that give you a flavor, I think, of the important sorts of questions I'm sure many of you are asking in this context of HSX and other sort of data sharing. Apologize for the technical difficulties with I took on a life of its own. Harm jumped in, pitch hitter there, Harm. Thank you so much. You did a great job.
We have a number of questions.
Questions. Yeah.
And I tried to bring them up during your talk, but I couldn't because now my screen was decided. That's okay. So first, Helen, thank you. I am so glad that you're studying this and explaining this, because is it tense? It's complicated. It's dizzying. And thank you for laying it out for us. That was very, very helpful, because we all have to, in this year where we're all focused on COVID, suddenly we have to focus on this. And I think that's why we're doing the series. That's why we have people like you on our webinar to make it suddenly very digestible and actionable for our members. So really, thank you very much for that. To our audience, if you have a question, please type it into the question box, and I will now open up my question box and do you see there, so one question is, do you see there to be a delay to the November 2nd, 2020 information blocking deadline? It's our understanding that there's an interim final rule circulating at OMB about this. So the question is, what is the actual deadline for the information blocking rules?
Right, so the compliance deadline, there's a couple of different, 2 layers to this question, to answer to this question. Number one, you're correct that there is an interim final rule that's floating around in OMB right now. We don't know what the content of that. It is referenced or titled a delay in a compliance deadline. So there is a suggestion. ONC has not officially at this point confirmed that delay would apply to any particular section of the information blocking rule, but it seems that it could be headed in that direction. There was a conference recently that a representative from ONC confirmed that they are looking, per at least this article from this conference, that during that conference, the ONC representatives himself confirmed that they are looking at the challenges that healthcare providers are facing in light of the COVID and are taking all factors into consideration, but would not at that time, which was at the end of September, confirm that they are delaying the rule. So as of right now, until we have official, I also know that the American Hospital Association just last week submitted a formal letter to ONC imploring them to please delay the rule, and rightfully so. It's just a lot for hospitals to deal with in particular right now. I speculate that there could be a different treatment potentially, where perhaps, for example, healthcare providers that are actors, since they're dealing with COVID directly, might have a reprieve on the delay, whereas maybe health IT vendors would not. Again, that's my speculation. I have no real source for that, but we'll see how that all pans out. With that said, I also wanted to mention that while the compliance deadline remains November 2nd, ONC has been very clear and said so expressly in the preamble that they would not begin enforcement, neither against HIEs, HINs, or health IT vendors, which would come out of the Office of the Inspector General, so the OIG, until a final rule for civil monetary penalties has been published. Right now, all we have is a proposed rule from OIG for civil monetary penalties. There is no final rule yet, and it does not look at this point that that final rule is going to be published anytime near November 2nd, but I hope they don't make me eat my words on that. Until a final rule is published, there's just no lever for enforcement, and so there will be no enforcement by OIG until that final rule comes out. On the healthcare provider side, there hasn't even been any movement ONC in the preamble said that they've collected people's comments, everything from there should be no enforcement against healthcare providers to everything to the other extreme, where CMP should be imposed against healthcare providers. And they merely have said that the standard is that healthcare providers, if they are found to be engaged in prohibited information blocking, they will be assessed appropriate disincentives by a certain agency, although they have not determined which agency is going to do that. They've shared the comments with HHS agencies, and that also has to be yet determined. So the long and the short of it is that it does not look from a practical standpoint that there's not going to be enforcement anytime soon. Moreover, they're not going to have any sort of retroactive enforcement, meaning that if you violated November 2nd, if that continues to be the compliance deadline and they begin enforcement January 1st, they're not going to go back to November 2nd to find that you violated something in November 2nd. At least that's what they've said in the preamble. So I thought that was important to mention.
Thank you, Helen.
Yeah.
A few more questions, and so one is a interesting question. What if a provider does not use an EMR but has a paper chart? What are the options and the enforcement for information sharing if the provider has a paper chart?
Right. So we're.
I'm worried that there's even a few of them still out there, but we know there's still a couple doctors.
Right. That's a larger concern. So the information blocking rule only applies to electronic health information. We're talking about the interference or prevention of the access, use, or exchange of electronic health information. And that's defined further as potentially PHI. After 2022, it's going to be the designated record set, but long and short of it is that paper records are simply not within the purview of this regulation.
Good. Another question. Complicated question. Do you have information on providers' direct email addresses needing to be entered in the NPPES site by June 30th, 2020? Do you know what will happen if this is not done regarding information blocking? Do providers other than doctors need to be in the National Provider Directory, for example, nurse practitioners, physician assistants, audiologists, etc.? Does that question make sense to you?
That is a technical question. I'm sure it's somewhere in the preamble, but I'm not off the cuff familiar with those acronyms. I don't know if Don, feel free to jump in here to help me out. But
this is specifically related to the provider directory requirements. So
yeah, it is. And so again, the rule applies to electronic health information. Yeah. And so I know that the treating provider, or the name or the identity of the treating provider, is one element potentially of a medical record chart. However, there's nothing in the rule, and I got this question also, maybe by analogy. Hopefully this will happen, help the person who's asking the question if I draw an analogy.
Also, it's 4 minutes before the end, so I would like to just move on. Several of you asked if the slides will be available. Yes, they will be. We'll post them. We'll post both the slides and the recording of this webinar so that you could listen and also see the slides again. I realized that the slides are very information dense. It'd be great for you to have those and look up some of the information, because it's still much more summarized than what you would see on the ONC websites. I want to thank Helen Oscislawski very much for her presentation and laying out the topic today. Super helpful and also really timely and important. I want to thank Don for the intro. I hope to see you all at the upcoming versions of HSX University. So there's one in 2 weeks. That will be October 27th. The speaker will be myself, and we'll go over many more details on the 21st Century Cures Act, specifically for both providers and for payers. And the next session is November 10th, and where we're talking about high trust certification. The exact dates, Helen is back. The exact dates will be on the Health Exchange HSX University website, and I'm sure you'll be getting emails from us about that. Helen, while you were off screen, I thank you for your detailed explanation. Do you have any final words to our audience?
Yeah, I just wanted to finish up the thought in 2 sentences that the rule does not require any sort of affirmative obligation to push data. And so I'll just leave it at that. So while you're not allowed to engage in practices that will prohibit data, there is no obligation affirmatively to push out data to the NPI, to patient portals, unless it's been requested. So with that, thank you all again. I apologize. This is the first time I've had technical difficulties. I'm so sorry, but hopefully the information is still conveyed. And I thank you both for your patience and everybody for their patience. Thanks so much.
Helen, thank you. Audience, great having you. Bye-bye.
All right. Good luck next.
Bye-bye.